Have you ever worried about copycats stealing your brand or hijackers taking over your listing? It's a real concern for anyone selling on Amazon or running an e-commerce business. In today's video, I'll show you exactly how to register a trademark from concept to official registration so you can protect your brand, steer clear for common challenges, and build your business with confidence. Hello everyone, my name is Asaf and I'm the CEO of Kabili & Co. and we specialize in intellectual property protection for Amazon and e-commerce sellers. In today's video, we'll explore the trademark registration process step by step, talk about why it matters, and share practical insights on handling any obstacles along the way. By the end, you'll have a clear roadmap to secure a brand and keep imitators at bay. So whatever you're a first-time entrepreneur or established seller looking to expand, or simply curious about how trademarks work, stick around and I'll cover it all. Now let's start by defining the core concept behind everything we'll discuss. What exactly is a trademark and why is it crucial for your business? Let's start with the basics. Trademark is essentially a word, a phrase, a symbol, or a design, or a combination of these that identifies and distinguishes the source of goods or services. Think of logos and brand names you've seen every day, like the Nike swoosh, the McDonald's Golden Arches, or Starbucks Mermaid. These are all protected by trademarks. But it's not just massive corporations that need them. As an Amazon or an e-commerce seller, your trademark is crucial for your brand identity and standing out in a crowded marketplace. Trademarks also protect you from others trying to piggyback on your success or imitate your brand. If you don't have a registered trademark, you're much more vulnerable to hijackers or copycats. Now that we know why trademarks are so important, let's talk about when you should file for one, because timing could be everything. You might be wondering, when is the best time to file a trademark application? So ideally, you should file as soon as you've decided on a name, a slogan, or a logo that you plan on using in commerce. You don't have to wait until your product is fully launched or your business is generating revenue. In the US, you can file on the intent of use basis, which allows you to secure your rights even before you start selling under the mark. This can give you a crucial head start in protecting your brand, especially if you're developing a product that isn't quite ready for the market. You must understand that trademark rights in most regions operate on a first to file basis. If someone else registered the same similar trademark, even just a day before you do, you can find yourself unable to register it. So getting the file process started sooner rather than later can save you from potential conflicts down the road. Next, let's explore the very first step in securing your trademark, making sure your chosen mark is really available. So let's talk about the trademark search. One of the first steps, and I can't stress this enough, is conducting a thorough trademark search. Before you start using a name, a logo, a slogan, you need to make sure someone else isn't already using it or has protected the similar mark. This involves checking the trademark databases in relevant jurisdictions. For instance, in the United States, there's the USPTO database. In Europe, there's the WIPO, and so on. The search should be done by your intellectual property attorney as it requires expertise. Even if you think the name is unique, there might be an existing mark already on the register that will block your mark from being registered. If your proposed mark is too close to another, the examiner authority might reject the application otherwise. That's why it is best to do your homework in advance. Let's say you've designed a stylish coffee mug and you plan to send it online and you want to call it Matcha Mate. You'd start by looking Matcha Mate in the USPTO or the WIPO databases, but you also need to check similar variation like Mocha Mate or Mocha Mates or even Mocha Mate. If you find a brand called Matcha Mug already registered for coffee mugs or related drinkware, that's a potential red flag. Even a small variation like mate versus mug might not be enough to prevent confusion in the eyes of the trademark examiners. By searching early, you'd know whether you should reconsider the name or consult an attorney before you sink resources into packaging and marketing. Once your search is complete and you're sure that your mark is available, it's time to move on to the filing stage where you actually submit your application to the trademark office. So let's talk about the basis of this process. So again, once you've confirmed that the mark is available and not infringing on anyone else's, the next step is filing the application. The process will differ slightly depending on where you're registering, but let's focus on the USPTO as an example. So first of all, you have to choose the right form. You'll decide if you're filing for a standard character mark, a word mark, or a design mark like a logo. Now we have to specify the goods or services. You need to list exactly which goods or services your mark will cover. For e-commerce sellers, this involves the specific classes of products you're going to sell, like clothing, jewelry, electronics, or other categories. So the basis of filing, you can file based on actual use if you're already using the mark in commerce, or intent of use if you plan on using it soon or in the near future. Each basis has slightly different requirements. Now submitting specimens. If you're already using the mark in commerce, you're actually selling, you'll need to provide evidence for that, like photos or selling pages, screenshot of the mark, where it appears on the product, the packaging, and so on. Now, let's talk about fees. Obviously, there's filing fees, which can vary based on the form you choose and how many classes of goods or services you're going to include. It is important to know that if you're not a US citizen or US entity and you wish to file a trademark application in the US, you must be represented by a US licensed attorney. This ensures foreign applications receive proper guidance on the American laws and procedures. Submitting everything properly the first time can save you a lot of headaches later, so meticulous attention to details here is a key. Once your application is filed, the trademark office takes over. And let's talk what happens during the examination phase and what to do if the examiner has questions or concerns. After filing, your application goes to the examining attorney at the USPTO. The USPTO will review it to ensure it meets all the legal requirements and that it's not confusingly similar to an existing mark. If everything looks good, the application will move to publication. However, if there are issues, you'll receive what's called an office action. This is basically a letter outlining the reason for refusals or requests for additional information. Office actions can be minor, such as clarifying the descriptions of goods, or more serious, such as likelihood of confusion refusal. If you receive one, don't panic. You typically have deadline to respond, and an experienced attorney can help craft a response to address the examiner's attorney's concerns. The key is to be clear, concise, and provide evidence for the argument supporting your mark. If you successfully addressed any issue raised during the examination, your marks proceed to the next step, the publication. So let's see what it means and how opposition can affect your application. If the examining attorney is satisfied with your application, your trademark is published in the official gazette. But this starts a 30-day opposition period in the US, during which third parties can challenge your mark if they believe it conflicts with their own. Most applications pass through this stage without opposition. However, if someone does file an opposition, the process can become more complex, often requiring legal proceeding in front of a trademark trial and an appeal board. This is another reason why preliminary searches and thorough planning are so important. By doing your due diligence, you reduce the risk of someone challenging your mark at this stage. Once you clear the opposition period, you're nearly at the finish line. So let's talk about what happened when your trademark becomes official and how to keep it that way. Congratulations! If no one opposes to your mark and you've satisfied any other formalities like submitting a statement of use, your trademark should be registered. You'll receive a registration certificate, and from that point on, you have the exclusive rights to use the mark for the goods and services listed. However, your responsibility doesn't end there. Trademarks require maintenance. In the US, for example, you'll need to file maintenance documents between the 5th and the 6th year of registration, then again between the 9th and the 10th year, and every 10 years after that. Failing to submit this filing will result in cancellation of your mark. Throughout this journey, there are a few challenges that tend to crop up over and over. So let's take a look at some of them and and how you can address or avoid them. Here are some challenges I've seen many applications face, along with my best recommendation. So first of all, inadequate research. Not performing a thorough search for similar marks can lead to wasted time and money if your application is being rejected. The second thing is misclassifications of goods and services. Choosing the wrong classes or product specification can result in office actions and delay your registration. Third thing, which is very important, is the strict deadlines. Trademark offices are unforgiving about deadlines, and missing them could mean starting the process all over again. Now, something that is your responsibility is enforcement. Once you've registered a trademark, it's up to you to ensure no one else is infringing on it. Monitoring the market and taking action against potential infringements is essential. If you're unsure about any part of the process, whether it's search, the filing, the responding to office actions, it is very wise to work with an IP attorney. I hope this breakdown has given you a clear picture of the trademark registration process. I know it can feel overwhelming, but with the right guidance, it's actually quite manageable and absolutely worthwhile for protecting your brand. If you have any question or want to help, head over to our website where you can learn more about the services we offer and even get in touch with our team. Thank you so much for watching, and if you found this helpful, please consider sharing it or leaving a comment below. Best of luck to you with your trademark journey, and I'll see you next time.